Good afternoon, everyone, and welcome to our webinar. A very popular topic on everything you ever wanted to ask about the Texas Medical Board. I am very pleased to have joining the webinar today Dan Ballard. Dan is an attorney with the firm Ballard, Simmons and Campbell in Austin, Texas. Dan has worked tirelessly to defend physicians, especially with Texas Medical Board complaints. And he has graciously offered to join us today to try to answer your questions, as well as just provide some general information that may be helpful to you in your practices. Just a reminder that Dan is not providing legal advice to any of us, but he cannot provide legal advice. So if you have a specific question about something in your practice, he can answer a general question, but not specific to your particular needs for your practice. So Dan, are you ready? We've got a few questions that were submitted ahead of time. We'll be starting with those, but I would encourage you in the audience to please enter questions at the bottom of your screen under the Q&A pod, and we will get to those hopefully before the end of our hour today. Just a reminder, the webinar is question and answer only. There really aren't any slides to download, and you will receive a copy of a link to the recorded webinar as soon as possible after we get it transferred over. So Dan, let's start with a real basic question that how is a lawsuit different than a Texas Medical Board complaint?
Okay, good. And actually prepared a little slide for this one. And it's important for physicians to understand just kind of in a conceptual sense the difference between medical malpractice lawsuit that gets filed in district court, in Texas or federal court or whatever, versus a medical board complaint that gets filed, because in terms of the ramification, potential ramifications to you, your practice, your future, your reputation, they're really, really different than each other. And with a malpractice lawsuit, there's a process of getting it started that's completely different than the process of getting a medical board complaint started. With a lawsuit, the patient has to, think they're mad about something, which is that's an easy one. That happens all the time. But they've got to go to a plaintiff attorney and sit down with them and convince the plaintiff attorney that maybe there's some meat on the bone here. And very importantly, they've got to have a significant injury, or else the plaintiff's attorney is going to say, I don't want it. I don't want to mess with this. Hey, I'm here to make a living, and you can't make a living as a plaintiff's attorney off of penny ante cases. You got to have big ones because it takes a lot of investment of time and out-of-pocket money by the plaintiff's attorney. Therefore, if it's a case with very little injury or even a moderate amount of injury, a plaintiff's attorney is likely to say, don't want it, not doing this. Sorry, nice to talk to you, but go away. With a medical board complaint, on the other hand, on the same, let's say the same medical situation. So the patient is unhappy with the advice they got from the plaintiff's attorney, which was go away. That same patient, they can file a board complaint in a New York minute by just Googling up the term Texas Medical Board, hit the medical board's homepage, and it's very prominently displayed about, hey, do you want to file a complaint against a doctor? Because that's what we, the medical board, I say we, I'm not part of them, but that's what the medical board is there for, is to receive complaints about physicians and then to put them through the process. Very importantly, it doesn't take a significant injury or a big injury or a moderate injury or a little injury. It just takes a patient who's mad, dissatisfied, thinks they were mistreated, thinks there was a near miss type of error, that kind of thing. That's good enough. So put it out of your mind when talking about a medical board complaint that gets filed against you. They didn't even get hurt. Nothing bad actually happened here. Not relevant to the discussion. The medical board wants to go ahead and hear about it and investigate it and see, do we have a systemic problem here, or was this one a really sloppy situation that got badly handled, by the physician or the office or whatever. And that's very important to them. And in a big picture sense, I think if each of you step back, it's very important to the whole, protection of the public, that somebody needs to regulate doctors just like they need to regulate lawyers, just like they need to regulate the public. Somebody needs to do that, and the board performs a legitimate, valuable function in that. Do they get carried away sometimes? I think so, but as a general proposition, it's part of the overall system, and it generally works okay. So that's kind of a difference there. A couple of other differences between lawsuit versus medical board complaint is that here on the slide, the second bullet point, a medical board investigation is not restricted to the complaint that the patient filed. They may file a complaint that you were rude to them, or that you just didn't listen, or you were distracted, or whatever, some silly little thing. But the medical board is going to get your chart and review it, which might be of 5 years worth of care on this patient, and they may see fit to send it out to a couple of board certified physicians in your field to review your chart and see how you've been doing here. And the answer might be, well, not very well, or your charting, is incomplete or inaccurate or internally inconsistent or many things that can be wrong with charting. But they will also look at how are you treating the patient, and is it right, and do you seem like you're up to speed and current, and all in a complaint that was about you were rude to me. Yes, it happens, and things get expanded and broadened into things that are way beyond the initial complaint that got filed. So that won't happen typically in a lawsuit. It just doesn't come up that way. But in the medical board context, it does come up. Another important difference is that all medical board sanctions against a physician are public, and I mean all of them. I'm just got a new matter in for a physician a couple of days ago where they offered the physician a remedial plan where we think you didn't quite handle things right about, maybe giving this patient records or something that they asked for, and we're going to offer you a remedial plan. And the medical board sort of sells the idea to you of accepting the remedial plan because it's not going to appear in our newsletter, and it's not going to appear, they're not going to go out and actively promote the idea that you agreed to be spanked a little bit in this remedial plan. And I think unfortunately, it's a little bit misleading to many physicians in that they think, oh, I'm getting a private order. I'm getting a confidential order because they're not going to publish it. It's like, no, that's not what they said. They said, we're not going to publish it in the newsletter. Well, they are going to publish it on your web profile at the Texas Medical Board. So when somebody looks you up, they're going to see that it's there. It is not a private order. They can see what it's about. They can see, what the little spanking was. And it will be small. It's just that it is public. So if somebody tells you, oh, I got a private order or whatever, no, they didn't. No, they didn't. They may think they did, but they didn't. It's out there. So next here is that it's so easy for patients to file a complaint. It's just a total piece of cake about that. And finally, a patient cannot take back a medical board complaint like they can take back a medical malpractice lawsuit. If the plaintiff's attorney gets into a case and decides, whoa, my client here is a total fraud, this is a big scam, or there's no meat on the bone here, and I'm sorry I filed this case, they can typically pull out of it or dismiss the case or whatever, or a judge will dismiss it for them if they, if they don't do it. But that's a big difference. Whereas with a medical board complaint, once that complaint gets filed and the patient decides, oh no, I actually love you, I didn't mean to do that, I was just mad, that's too bad. Because that train has left the station and you're not going to back it up back into the station. It's out there. So those are some of the main differences, but they are significant differences in terms of should you pay attention in your daily practice to things that can be done to avoid, irritating patients to the point that they file a board complaint, some billing dispute or that kind of thing where they go file a board complaint against you, and we're off to the races. So it's an important area. So yeah. So Kathy, next here.
So Dan, what would you or how would you describe the mission of the Texas Medical Board?
Yeah. The board is clear that their mission is to protect the public, and you may ask, protect the public from who, or protect the public from what exactly? And very importantly, the medical board in Texas and in each state is there to protect the public from you guys. And it's like, wow, really? Yeah, I hate to say it, but that's their job. That's their mission, is that they are set up to regulate physicians, and regulate includes processing complaints about rule violations, about standard of care violations, and nowhere in their mission statement does it say, oh, and we're going to protect doctors from patients. That is just not there. It's not part of their deal. And, so somebody files a complaint on you and it gets dismissed, and they file the same thing again and it gets dismissed again, and then they appeal it and it gets dismissed again. Gee, what can I do to stop this nonsense? Well, not much. Not much. That's not the medical board's deal. They're there to protect the public. So consequently, you should view them as, and I don't think this is even really just by analogy, they are in a way a law enforcement agency, because there are laws that have been passed by the legislature that regulate physicians and how you have to do certain things. And the medical board is the governmental body that's there to make sure that you're following the rules and doing the right stuff, and that you're complying with the standard of care in your treatment of patients. So in a very real sense, they're enforcing the law. And consequently, when you get a medical board complaint, you should not assume that the medical board is your friend or your colleagues, or hey, they're just guys like me here. If I were a physician, which I'm not, but they're just guys, like me, who are going to understand my position and understand what I go through daily with patients, and how hard this is, and how hard it's been through the pandemic. And that's not their deal. They're there to enforce the laws against you. So it should be, you should just be aware that their attitude will be as law enforcers. We're going to investigate, we're going to decide, and we're going to let you say what you have to say for yourself, and then we're going to make a decision. And so think of it that way, and it will keep you from doing things like opening here's my letter from the medical board, this is ridiculous, and sort of tossing it aside either physically or mentally, and saying, this is just stupidity here. I don't need to respond to this. Well, yes, you do. When a policeman pulls you over on a traffic stop, you need to stop. You need to give them your driver. You need to go through the process. It's what they do. And And it's just like that here. It needs to be treated with the respect to which it is due, which is a lot. And, so don't go writing crazy letters and things to the medical board because you're mad or because, this is unfair or whatever. That's not productive in terms of getting you back to doing what you want to do, which is practicing medicine. So yeah.
So, Dan, you talked about how easy it is for someone to file a complaint with the Texas Medical Board. Can you walk through the investigation and hearing process with us?
Yeah. First, let me actually start with a complaint. Uh, um, like I said, you go to the medical board website, a patient will go to the medical board website and look it up, and it's a really easy to follow process where it's kind of set up on a web page with what's the problem here, and they describe the problem and who's the doctor, and they put in the name, and then they hit send. You just got a medical board complaint. It could take 3 minutes if somebody's good, fast typist, and it's a not too complicated deal. 3 minutes, and bam, you got a complaint, and again, we're off to the races here. Well, what the board will do with that is they're going to send you a letter that needs to be opened promptly and read promptly and dealt with promptly. They're going to send you this letter that's going to briefly state what the complaint is. There's 2 sections in the letter, and the first one sidetracks doctors constantly about, oh, this is about unprofessional conduct and non-therapeutic prescribing. And it's like, I didn't prescribe anything to the patient, and I wasn't rude to the patient. And doctors get sidetracked on that. Sort of, I'm going to say, set those things aside. And what you focus on is the paragraph that's written in italics for you. It's the only paragraph in the letter that will be in italics. And it states, on such and such date with patient, Mary Jones, you prescribed an antibiotic that gave her a bad reaction, or whatever the complaint is. And it'll state that, and it will ask you to provide a narrative response and kind of, hey, tell us what you have to say for yourself here. That's what they're asking. And you need to write down a clear, coherent, understandable letter that's not for an expert. It's not for somebody in your specialty. It's for an investigator or a physician who's a generalist, and to where they can understand, gee, in this retinal cancer treatment case, they can understand that I treated this patient within the standard of care. Here's the literature that supports me. Here's what happened. Here's what I explained to the patient. Here's the consent forms. Yes, we had a complication. It's in the consent forms. It happens, and here's the literature about that. And that lays it out in a form that a medical person can understand it, believe it, and say, this looks pretty good to me, and hopefully dismiss it at that point. So that's one option for what can happen there, is it can get dismissed early, like about 2 weeks after you send in your letter, and you're done. That's it. It's over. The other option is that it's not clear to the screener person here, did the doctor meet the standard of care or not? So I'm going to kick this one into an investigation, which starts a many months long process of gathering the medical records. That investigator will gather the medical records. They'll get your records. They'll get other related records. They will package those up and send it out to 2 board-certified specialists in your specialty, whatever it is. If it's primary care, they send it to primary care, board-certified internist, family practice, whatever. If you're a retinal surgeon, they send it to 2, specialists in that area. So they do that. They get a vote between those 2. If it agrees on either the care was fine, we're good to go, they'll dismiss the case at that point. If they don't agree with each other, they'll get a third one as sort of a tiebreaker. And again, it's a thumbs up or thumbs down vote there, where if they say, we think there's a problem here, then they're going to set you for a hearing. They'll send you a letter. We're probably now 6 months down the road, 8 months down the road maybe. They'll send you a letter that says about 3 months from now on this date at this appointed hour, you will have an informal settlement conference. I'm going to call that a hearing because you need to think of it as a hearing, a sort of court-like hearing, because while it's informal in a technical legal sense, it should be dealt with very formally in terms of your preparation, your presentation. It's your day in court, basically, and you need to act like it. So you need to be ready. You need to have filed, a response letter to the two board-certified experts, to their criticisms. You need to respond to that in spades, and with all the literature you can gather up or things like that that support your position, your treatment, and send that in writing, and then go to the hearing, make your appearance, be cool, calm, and collected, and be the smartest person that ever walked in that door. You need to prepare for this process like you're going to take your oral boards. It's a big deal. Now, I'm going to back up a step and say that as part of this process, I think, as a lawyer who does this, and I have a lot of experience, I've done it for many years, I think you should hire a lawyer through your insurance carrier. You have coverage for it, and I think you should use your insurance coverage to pay for a lawyer to help you from the very word go. Very importantly, before you ever respond to the medical board in any way, you need a lawyer. This is not a medical process that you're going through. This is a legal process that you're going through, and hopefully you've never been through it before. But even if you have, and it went great for you, and you handled your own case, you need a lawyer. So call up, in this instance, TMLT, call them up, tell them you got a thing, and they will get you a lawyer. There are scads of good lawyers in Texas that do this, and they'll get you a lawyer. And you've paid for it, and in my personal opinion, it's kind of professional suicide to not utilize it when you've already paid for it, because lots of mistakes get made, and it's just, it's kind of don't do surgery on yourself, and don't go to the medical board by yourself. It's just not a good idea. So that's kind of the backup, and get a lawyer to help you through this process. But where I was I was saying you would have this hearing, I'm going to call it, and the so to speak judges at this hearing are going to be one physician, probably not of your specialty, and one member from the public who's just a Joe Schmo who's been appointed by the governor, they will have had some experience of sitting and being a sort of a judge here in these hearings, but they're not a lawyer probably. They're not anybody. They're a business person. They're smart. They care about what they're doing. But do they understand all the medical details of it? No, they don't. So that typically the physician on the panel is the one who has read your stuff that you filed, hopefully understands it, and because you've written it with an eye toward not having a physician of your specialty who's going to be there that day. You're an orthopedic surgeon, well, you may get an OB-GYN who's your doctor. You may get a psychiatrist. You may get an internist. You may get anybody but an orthopedic surgeon. And I just use that as an example. That's true across all specialties. You may get somebody else who just doesn't know what you do, doesn't know how to do what you do. And consequently, they may feel like, I got to rely on what the board's hired experts said about you in this case. So you've got to be ready to go in and show that the board's experts are wrong. They are hypercritical. They are out of date. They are whatever. So you've got to be able to show that they're wrong. So that's the kind of the hearing process. They make a recommendation at the end of this 45-minute, little hearing here. They make a recommendation that will get turned into a proposed agreed order. It'll get written out on about 6 pages of typed out stuff, and it'll get sent to you to either agree to or to not agree to, or perhaps negotiate a little bit about, but they're not going to just be talked into dropping it at that point. And to move a little further in the process, sort of into appeal aspects of it, if you are just not going to agree to what the board has proposed in terms of you need to take CME, you need to pay a fine, you need to have chart monitoring, you need to do things like that, and you're just not going to agree to it, kind of the appeal process is to say, I'm not doing it, and sue me if you want to, which they will. And they file a lawsuit against you. It's a formal public lawsuit. So it's the first time that this investigative process has become public. As of the minute that that document gets filed at the state office of administrative hearings, bam, it's now public. So that cat is now out of the bag and can't truly be put back in the bag. But it's formal lawsuit, just like filing a lawsuit down at the courthouse. And from there, this is kind of your appeal. It's a sort of appeal because what it ends up with is a trial there in front of an administrative law judge who is just going to decide, here's basically the facts as they find them. And which may include I think you breached the standard of care in the issuance of this prescription for this antibiotic, it was the wrong one or whatever. If they make that finding, any finding against you, then the whole shooting match gets sent back to the Texas Medical Board for them to assess the penalty. The administrative law judge is not allowed to set the penalty. It can only be set by the medical board. So when I said there's sort of an appeal here, that's why I say sort of. You do get a new, time at bat on this, but you got to hit a home run. If you don't hit a home run, then it goes back to the medical board. If you do hit a home run and you convince the administrative law judge that there is no problem here, I did not breach the standard of care, I did not violate any rule, I did not have any charting problem, then the case is over. But that's a hard thing to do in most cases that have gone this far in the process. There's usually a little bitty tiny little bit of something where it's like, you really could have and should have done a little bit better job on such and such. Goes back to the medical board, they assess the penalty, and they can really be about as harsh as they want to. And now that you've made them spend a few tens of thousands of dollars, prosecuting this case against you, they may feel harsh, and that's just that's the way that system goes. So yeah.
So Dan,
Kathy
it looks
here.
like, yes, it looks like we're getting quite a few audience questions. So let's jump in.
Okay.
Does having an attorney help in an appeal to the THPP?
THPP.
Is that the Texas Health Program? Is that what
Not the
that
usual name. I call it by the PHP. I'm going to interpret this as to the PHP, Physicians Health Program, and I'm going to assume that that's what the question's about. And just for those of you who don't know that agents, it's sort of an agency. It's sort of an offshoot of the medical board, but it's about impairment issues, which can be health impairment. You had a stroke. There's a question about whether or not you can continue doing your business or your surgery or whatever. You have drug impairment. You have alcohol impairment. You have mental impairment. Are you having some dementia? Whatever. It's for impairment issues of those types, and the PHP will evaluate you and get you on a confidential, this is important, a confidential, non-public plan, if possible. I mean, it's like if you have dementia, it may be, okay, we can't deal with that very well. But if it's, for example, a substance abuse issue, they will get you on a plan of let's fix this, let's improve, let's get back on track, and it stays confidential. That's huge. So they are not actually the medical board. They're separate. But the question here is, does it help to have a lawyer, when you're dealing with the PHP? Maybe a little, but only initially. The people at the PHP, in my opinion, have their head on straight. They have their heart in the right place. They are there to help you. They are not there to run you into the ground or get you out of practice or make you fail or whatever. These people have their heart in the right place. And there's not really much need for a lawyer in that situation, because I think that they're going to help you. They're going to, if you trip, they're going to pick you up. And it's a great program, I think. So a lawyer is not really a key aspect of that particular program, I think. So yeah. Next
Good.
here, Kathy.
So I did change the background so that everyone can see the website for the Texas Medical Board. Of course, you can simply search in your search engine for Texas Medical Board, but this is what their homepage currently looks like. So the next question is, where can you find the TMB rules or guidelines on using locum tenens?
Okay. Let me take this question apart into two sections. First, where can you find medical board rules? I don't know, Kathy, if you can put a cursor on that screen and go to if you're able to, or an arrow or something, the top center tab of the very tip top, laws and rules. Slide to the right by 3 items, keep going, right there, perfect. That says laws and rules. If you were to click on that tab on a live website here, it would take you to another page, and it would have a tab for board rules. And click on that tab. It then breaks it into about, 50 subsets of rules here. And from there, if you kind of know where you're headed, you can click on one of these subsets of Rule 165 or Rule 170 or whatever. If you don't know where you're headed, and it's like, for example here, glad I got this question on how do I look up rules for locum tenens. I don't think that there are rules in the medical board rules. I can't say that I've ever tried to look that up, but I don't think that there is a rule about how to use locum tenens or that kind of thing. There is one, you'll find at least one reference in Rule 165.5 probably to locum tenens, which is when you're moving away from a medical practice, relocating, quitting, or whatever, like a locum tenens would do at the end of their term, however long they've been employed to come there. That says if you were just a locum tenens at this practice, you don't have to do all of this stuff about notifying patients that you're leaving. So there's that one reference that, again, I think is in 165.5 probably, or thereabouts. But other than that, I actually don't know if there's a rule about how you do things with locum tenens or not. I don't think there is, though, because I can't recall reading it.
Isn't it fairly well expected that if locum tenens or full or part-time physician, everyone participates in the Texas Medical Board rules as
Yes,
they're written
yes.
because you're
Yes,
licensed
yeah,
in
yes,
Texas.
and if your comment is a locum tenens physician covered by, regulated by, needs to follow every single one of the Texas Medical Board rules, all the statutes in Texas that apply, Yes, absolutely. They are just like you as a physician. They're stepping into your shoes and they need to act like it. Yeah.
Okay. Um, this one is on medical records retention. Boy, we could probably talk an hour on this one, but let's see if we can cover it in a couple of minutes. How long
Okay.
should physicians, I would say, how long must physicians retain medical records?
Uh, yeah, and yes, it's a two-part answer. 7 years. That's the general rule, is retain records for 7 years unless you know that there's litigation uh, involving them, and unless it has to do with a child who has not yet reached the age of 20. Uh, 7 years, and you can dispose of them after that for ordinary adult type situations is the typical rule.
Very good.
Okay.
Here's a telemedicine question. Uh, can telemedicine be conducted from outside the country? Say the physician licensed in Texas is traveling abroad for a period of time.
Okay, good. Yes, it can. If Neil Armstrong had been a physician, he could have, seen his patients while he was out, jaunting around on the moon. Yes, you can. Here's the key: is you are practicing medicine where the patient is. And if you're off in Europe or whatever, can you have a telemedicine visit with a patient who's in Oklahoma? No. With a patient who's in Texas? Yes. If you have an Oklahoma license, you can see the Oklahoma patient, but not if you don't. So it's where the patient is, that's the key, and where you are is not particularly relevant. And let me think whether I want to make any, no, I don't think I want to make any exception to that I can think of. So yeah, so it's where the patient is. That's what matters here. And very importantly, don't go off seeing patients. Don't set up I'm going to be a specialist in such and such care, and I'm going to see patients nationally because hey, I'm here in Texas. That's right, you're here in Texas. Your patients aren't, and the Michigan Medical Board's going to have a problem with you seeing patients who are located in Michigan. So you can't do that. But if they're here, you're good to go. Good. Next
So
here.
the follow-up to that, I guess, is, and maybe the easiest is just to kind of point people to the TMB rules for telemedicine, because what should be included in an adequate consent for the telemedicine visit is the next question.
Yes. I'm going to say the general consent to treat is very similar to a general consent to treat that you would have in your usual kind of sign-up paperwork. But it has a little bit of additional, you need to, and I can send you a consent form or the additional language if you, why don't you email Kathy and she can round up questions on this if you get several. But basically, it adds a little bit of consent about, okay, we're doing this via telemedicine, and therefore you're consenting to do this via telemedicine, and you understand that, hey, we could lose our connection, or hey, I might have to, send you off to another care provider if I discover that I can't treat you via telemedicine, or I may have to have you come in, or that kind of thing. So it has just a little extra paragraph about that telemedicine's a little bit different, than in person. But I could send you a little bit of language on that. But yes, it is a different consent to treat. And that's on sort of a general consent. In terms of suppose you're going to actually prescribe or order treatment for someone via telemedicine, and it's a kind of thing that you deem necessary to obtain specific consent about this. Okay, I'm going to treat you with an off-label use of this drug. I'm not, and let me be clear. I'm not suggesting you need a consent form for any and all off-label uses of drugs. That's not what I'm saying. But suppose in this particular instance, yeah, this one is a really kind of special, off-labelish use. This really could have side effects. I want you to understand, about these side effects and potential complications and whatnot. And you feel like I need a consent form. To do that, you can obtain the patient's consent verbally, but you've got to chart it, which is really true in the office also. You can receive consent verbally, but you got to chart it. So same rule there. Or if you want to use a written consent form on it, you can email it to them. They can email it back to you and that kind of thing. So it's pretty similar in that respect to in office. Good. Next year, Kathy.
The next question has to do with vaccine exemptions. Is it a requirement for providers to sign off on religious exemptions for vaccines of the employee? I guess I'm taking this to be an employer mandated vaccine.
That is an interesting question. I'm going to generally say that you don't have to sign off on any vaccine-related or mask-wearing related exemption that you don't see fit to sign off on. If you don't think it's a legitimate deal or you don't know if it's a legitimate deal, you don't have to put yourself out there and sign off on it. And importantly, I want to include mask wearing, for school kids and whatever. These exemptions can be an invitation to a medical board complaint against you because mom comes in and says, hey, little Johnny doesn't like wearing a mask, and can't you please just sign an exemption for him? And you sign one, and the teacher's like, huh? Why? And all the other kids are required to wear them or whatever. So you don't have to sign off on that stuff, and it's kind of asking for trouble in some circumstances, especially if you feel like this is a little bit bogus, but I'll sign it anyway. Okay, you're asking for it. So I'd say don't do it. But to readdress the question here about religious exemption, I don't think I don't think a physician has to make a decision that, okay, yeah, this is, the patient says it's legitimate and therefore it's legitimate. It's kind of like, by analogy, treating pain. The patient says they have chronic pain and therefore I have to treat it. It's like, no, you don't. If you don't deem it to be legitimate, you don't have to do it. And even if you do deem it to be legitimate, I don't think that it's part of your licensure that you have to sign exemptions on vaccines or masks or getting off work for 3 days or whatever. I don't think you have to do that if you choose not to do that. Yeah.
Good. Is there any
Kathy.
initial screening on Texas Medical Board complaints that allows the board to dismiss frivolous complaints?
Yes, and yes, I think there is, and it's this process that I described where they send you a teeny tiny paragraph about here's the complaint against you. What do you have to say for yourself in writing? And you respond in writing to that request, explaining yourself. This is a crazy, situation, whatever. And if you can adequately explain it, then they are basically going to, in essence, deem it to be a frivolous complaint, and they're going to dismiss it at that point. So yes, that is part of the process. And something I did not emphasize earlier that I'd like to hear is that this first narrative response letter, in many cases, is the best shot you are ever going to get to just get this case dismissed. And therefore, your response needs to be fantastic and on point and clear and not wander into the weeds. And again, I think you need help with that. It's like, I'll give a sort of a little far-fetched example of, if you're going to Africa on safari, do you want to take a guide? You know, even though, hey, I hunt around Texas all the time, or blah, 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 whatever, hunting in Africa may be different than hunting in Texas, where in Africa you're sleeping out with the lions. And here, you know, it's the same kind of thing. I would just encourage you to, you know, do the best you can to make sure it goes right. So it's a very important letter that you're writing there. Next here.
Could you comment on the current situation with the board and opioid prescribing?
Yeah, the opioid, the board is not as active as they were, I'm going to say 8 to 10 years ago. 8 to 10 years ago, it's like they were all over you guys about opioid prescribing, especially in the chronic pain context. And that has calmed down some, because a lot of physicians have gotten the message that we got to get with the program here. We got to read the rules and know the rules if we're going to be prescribing opioids, especially for chronic pain. And the practice of medicine is probably better in that respect than it was. I think it's better. It's what I see as better. But you know, there are other things that are much more prominent these days. But one important thing I do want to mention about prescribing, you know, opioids, is that there is a limit that got put in place by the legislature for, if you're treating acute pain, which is pain for the first 30 days of the pain, that's acute pain, and it then cycles off into sort of medium-term pain and then chronic pain. But for acute pain, there's a 10-day limit on the prescription that you can give for opioids for treating acute pain, but it's not an absolute limit. It just means that you need to bring the patient back in physically, have them come in where you can lay eyes and hands on them and do an exam about their pain. And you can then give them another prescription for another up to another 10 days if they need it. But you do have to see them to do it. You cannot just say, oh yeah, I'll call you in, you know, another set of hydrocodone here, or, you know, whatever. You got to bring them in and see them. So that's an important, very important criteria there, is that at the end of that first 10 days, you got to bring them back in. And then if you need it another 10 days after the 20, you got to bring them back in before you can give them that last section of acute pain treatment. So that's an important change, that, you know, nothing would necessarily stop you from just e-prescribing it out. You know, the pharmacy's not going to know, and they're probably going to, they're not going to know that you didn't see the patient again, and they're going to dispense it. And then somehow somebody gets mad, a disgruntled employee, you know, files a complaint against you, you know, because, hey, you re-prescribed for this patient without bringing them in, and everything's a mess then. So follow that rule. Be real careful about it. Yep.
So a couple of questions have come in related to board action against physicians as it relates to COVID misinformation. Do you have any comment on that?
Yeah. Yes. Stand your ground with patients who are misinformed or whatever. You know, one area on that would be, you know, the patient doesn't want to get a vaccine. Well, you can't make them get a vaccine, but you can try to educate them, if you are a believer in vaccines, that the current science and the, you know, CDC and whatnot recommendations are: get a vaccine, get a second vaccine, get a booster, whatever. But you know, you can't make them do it. And you know, in terms of another very important thing about COVID and medical board attitudes is that if you are of a mind to prescribe, and I'm going to emphasize prescribe, home treatment via prescription medications for diagnosed COVID, but at home, such as the easy example is ivermectin, budesonide, colchicine, hydroxychloroquine, any of these that are not specifically approved, or recommended by NIH, CDC, FDA, anybody, nobody's recommending these for the treatment of COVID. If you are of a mind to prescribe those, you need to be well aware that the board's attitude is going to be negative about that because the board, I'm going to say, they are following the mainstream, I won't use the word rules, following the mainstream guidelines, about how to treat COVID at home, which is not with these drugs. And it's like, okay, well, how do you treat COVID at home? That's a good question, but it's not with these drugs. And if you're going to do it, you stand a chance of getting reported by pharmacists, by competitors, by ER doctors, by whomever, when the patient shows up and, and says, hey, I've been taking ivermectin from Dr. Jones here and da-da-da. Some physicians are apt to report you to the board, file a complaint against you, and the board is apt to have a negative view of those. So beware that you may be kind of drawing a line in the dirt for yourself and needing to defend yourself on those, and it may be hard, because you're going to be stacked up against sort of the heavier hitters at the medical board who are going to take an interest in that issue. It is an issue. Somebody asked about opioid, the issue. Well, this is an issue. Here is alternative treatments for COVID. So be aware when you go down that road that you are going down that road and you're asking for a fight with the medical board about it, and because we're defending several of those fights, on behalf of doctors, and and you don't have to agree with it or disagree with it. I don't have to agree with it or disagree with it. It's what we do, and we will defend those situations. And gather up the literature and make, a case, for those, make the best case that can be made. And I think that kind of covers, what's the board thinking about COVID.
If you have a patient from Texas traveling to another state, can you treat them with telemedicine?
Yeah, that's a good question that does not have a crystal clear answer. Well, actually, it may have a crystal clear answer. Technically speaking, you probably shouldn't. Technically. Now, if there's anybody in the audience who's as old as I am, you've been treating patients for 30, 40 years, and you could probably think of a few hundred times when you've called in prescriptions to somebody who's off on vacation in Colorado, somebody who's on a business trip in Chicago, and they left their blood pressure meds at home, and you want them to have their blood pressure meds today, not tomorrow or later or whatever. They need to be taking them, and you call them in for them, and nobody gets in trouble about it. Is it technically legal? I doubt it. Are you going to get in trouble for it? I doubt it. So I think you can see where I'm going about it. What matters is where the patient is. Could you fly up to Chicago and go up there and be with your patient who's there on a business trip and write them a prescription? It wouldn't seem right. Could you, alternatively, could you call in a prescription renewal here for that blood pressure med, call it into Walmart or CVS or whatever, and maybe the patient can figure out how to pick it up, while they're away? That's a little nicer maybe cleaner way to do it. But technically, is there some kind of exception that lets you treat your patient while they're away and out of state? I don't think there is, but I also don't know if I've never heard of a situation of somebody actually getting in trouble, for treating their traveling patient. I do also have what I'll call the television rule, which is if the person has taken their television with them on their out-of-state trip, like a college kid who's moved away and is going to Northwestern University whatever. If they took their television, I don't think they're just traveling. I think they moved. And if they moved, then they need to go get a doctor up there. And you need to be highly reluctant to be getting pulled into that deal. So anyway, but yeah, not a clear answer, I understand, but I can't do any better. Sorry.
So,
Kathy, yeah.
Dan, we're getting really close to the end of our hour.
Okay,
I've
okay.
just moved the pointer down to the uh, part on the Texas Medical Board homepage that talks about joining our email list. I know that's one of the things that you are passionate about. So
Yeah,
you want
yes,
to just mention
everybody
that real
go to that
quickly?
home. Yeah, go to that homepage and find that little red background area on the medical board's homepage and type in your email address and hit submit. Uh, and it will get you on the medical board's newsletter list that otherwise you're not on if you haven't done this. And it gets you all of their news alerts, all of their new rule alerts, all of the stuff that you need to see. And they don't do any spamming ever. So it's all good stuff. You need to see it. So please get signed up for that.
Let's see, I'm going to skip over to our very last slide. And just remind everyone that we will be sending a CME, or I'll be launching the CME evaluation in just a moment. It will open in your browser, and you may have to close your browser to be able to see the webinar screen again. But after that, we would also encourage you, if you do have questions, to send them to consulting@tmlt.org. Dan referenced that on a previous answer. We certainly will try to get you an answer if you send them to consulting@tmlt.org. I know there were a lot of questions that we did not get to, and and certainly this, I think, just shows what a hot topic the Texas Medical Board actually is. Thank you for your participation. Thank you, Dan, for joining
Sure.
us today, um, and sort of being the target of all the questions. And we certainly appreciate the work that you do for physicians who are finding themselves in the situation of having Texas Medical Board complaints.
Thanks.
Thanks, everyone. Hope to see you in January uh, with a new webinar topic. And everyone have a safe and happy rest of 2021.
Thanks, guys. Bye-bye.